All right, we're back on the record. This is file number 231670. People versus Sean Allen Jordan. That's you, sir?
Yes, sir.
And I've known you since you were in high school, but I'm identifying you for the record. You're charged with some very serious offenses. It's alleged that on or about August 27th, you did knowingly restrain Jesse Pike to facilitate the commission of assault with strangulation or suffocation, a felony. That unlawful imprisonment charge is punishable by up to 15 years in prison and a fine of up to $20,000. Count 2 was assault with intent to do great bodily harm less than murder by strangulation. You did make an assault upon Jesse Pike by strangulation or suffocation, contrary to the statute. That is a felony punishable by up to 10 years imprisonment and a fine of up to $5,000. Count 3 is aggravated domestic violence that you did inflict upon Jesse Pike, who you had a dating relationship with, a serious or aggravated injury.
Excuse me, I believe there's an amended complaint.
Is there? I just printed this yesterday. We got another one.
The amended complaint was filed a couple of weeks ago.
Well, once again, I didn't scroll down far enough. The same thing happened yesterday, so it's on me. Unlawful imprisonment, assault, great bodily harm. Count 2. Count 3, assault, great bodily harm. Same suffocation. And count 4 is aggravated domestic assault. That's a misdemeanor charged as a fourth habitual offender, making this a mandatory minimum 25-year sentence. So this is a very significant charge, Mr. Jordan. This is a preliminary examination where it must be established that it's probable cause to believe that a crime was committed and probable cause that you did it. You don't get found guilty or not guilty at this hearing. But if it goes to circuit court and you get convicted, you have to do 25 years in prison, the way this is charged. Mr. David Marvin, the county prosecuting attorney, is here. Mr. Marvin, is there a plea offer?
All right, give me 1 second. Your Honor, to answer your question, there was an offer. It was count 2 and count 4. Dismiss the remainder, and that does eliminate the mandatory 25-year sentence. That was restated, and now I defer to John Bush.
All right, count 2 is assault with intent to do great bodily harm. Count 4 is aggravated domestic assault. The unlawful imprisonment, the other charge, and the supplemental would be dismissed. Mr. Bush, have you had a chance to discuss that with your client?
I had, that was the same offer that we've had before, Your Honor, and he said no then, and he's also telling me no, and he wants a prelim today.
Very well. All right, Mr. Marvin, are you ready to proceed?
I am. I don't often ask for an opening statement, but would the court allow that?
Certainly.
All right. Your Honor, I think we'll do the best we can today. There are a number of ways of getting testimony in situations like this when you've got a victim who's very reluctant. And but I just wanted to let the court know that today I'll be asking questions about the Sean Jordan who acted on the day of this incident, and not the Sean Jordan that Jesse Pike really cares for. And I just wanted to let the court know and remind Jesse Pike of that.
All right. Mr. Bush, any opening from you?
No, no.
Ms. Pike, would you come up and take the witness stand? Why don't you bring that box of Kleenexes right up with you? Would you please face me and raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
All right, have a seat and state your name, please.
Jesse Anna Pike,
Could you spell your name for us?
Jessey, and then Pike.
ANNA.
Yeah.
All right, I ask you to keep your voice up. Mr. Marvin has some questions for you.
Good afternoon, Jesse. All right, and say it again, because you're going to have to speak very clearly and loudly.
Good afternoon.
All right. Jesse, do you recall August 27th, 2023?
Yeah,
Do you know the day?
not exactly like the day of the week.
All right. On or about August 27th of 2023, did you contact law enforcement?
Yes.
What was that?
Yeah,
Okay. Where were you?
the bedroom,
But where were you? What address?
1135 Millard Court.
In Three Rivers?
Yes.
All right, and that's in St. Joseph County.
Yes, I'm
Okay.
not from here, so yeah.
All right. So you contacted law enforcement. Would you tell the court, why did you contact law enforcement?
I was frightened and I just wanted,
Could you please?
I was frightened and wanted help, like to get separated.
Okay, so you're calling for help. And why were you calling for help? Just big terms. Why were you calling for help?
Argue.
And arguing with whom? Could you say who?
Sean Jordan,
All right, and do you see him today? And where is he?
sitting right there.
All right, Your Honor, she nodded, may the record reflect, she nodded towards defendant.
It may.
Did law enforcement arrive?
Yes.
What did you tell law enforcement? What happened that day?
I got hurt.
You got hurt? Who hurt you? Your Honor, I would,
Well, let's try another. What time of day was this? Was it dark out?
I don't know,
Do you know what time you called the police?
like around 9, I believe.
All right, why don't you go from there, Mr. Marvin?
Your Honor, could I guess that one thing I could request is that I examine this witness as like cross, I guess, as a hostile. I could treat her as a hostile witness. I'd ask that. Otherwise, I'm afraid this might be a situation where I have to request other testimony in another way. We might have to reschedule it.
All right, well, Mr. Bush, any response?
My client. Yeah, I'm not satisfied with, we've reached a level that she can be treated as a hostile witness, but I would have no objection to a brief recess if Mr. Marvin wants to talk to her.
All right, well, let's see where we go here. Miss Jordan, Miss Peterson, or excuse me, Miss Pike, let me get it right. You got a subpoena to be here yesterday.
I did not get a speech.
Okay, but did you get a subpoena to be here?
Inadvertently, they had 1137 Millard Court.
That's what it
That's
says
what-
here.
It's 1135.
All right. Well, you're here now. Did you come with a subpoena?
No, I came because the police tracked me down at my work.
All right,
This was a verbal agreement to come back today
all right.
after yesterday. She cooperated and was
Well,
good
yeah,
about it.
yesterday we got delayed, so we set this for today. Are you uncomfortable being here?
Yes,
And did you talk to Mr. Marvin about this case?
yeah, yes.
And are you reluctant because you don't want Sean to get in more trouble?
No, I don't want him to get in trouble.
He's in trouble. And he's been charged with these criminal offenses. You have a obligation, as you're under oath, to answer the questions truthfully. And so I'm going to allow Mr. Marvin to do this as if he were cross-examining you as a reluctant witness.
Thank you, Your Honor. Jesse, is it true you contacted law enforcement for help?
Yes,
And when you got there, is it true you had injuries?
to my eye.
All right, so you had an eye injury. How did you receive the eye injury?
All right, just a minute. Can you answer that? How did you receive the eye injury?
The record can't reflect she's shaking her head no, Your Honor.
Are you unwilling to answer the question?
I don't want to answer.
Your Honor, may I ask a series of yes or no?
Let me explore this a little further. I don't want to answer isn't a sufficient answer. People are often here and they have to answer something they don't want to do. But you're here pursuant to a court order and you're under oath in a capital case. So the fact that you don't want to answer the question doesn't mean you don't have to answer it truthfully. So you indicated that you were injured. Can you tell Mr. Marvin how you got the injury?
During the argument, I don't know exactly what happened. I was kind of flailing around. I don't know exactly what happened.
All right, Mr. Marvin, you can ask questions.
Where did that injury happen? Where were you? Oh, so you're in the bedroom. Why were you flailing?
Because of the argument, and I was worried and instantly felt like I wanted to get out of there.
Were you not able to get out of there? Jesse, is it true that you were in the kitchen making toast? You bumped the refrigerator door, hit you. You got mad, or Sean got mad because you're in the way and he hit you. You took your toast and you retreated to the bedroom?
Stop. Is that true?
I don't remember being in the kitchen at all.
All right. Your Honor, I don't know how to move forward. I could move forward and treat this victim as though she died that night, and I am afraid that's what I'm gonna have to do.
Well, these are very difficult cases. We had 3 this week where they're alleged to be very serious assaultive injuries inflicted by men on women. In each case, the female, the complaining witness, was reluctant to testify. A very bad case yesterday where an animal was killed, and had another case where a woman was badly beaten about the face. And now we have this case. So in each of those 3 cases, the victim was reluctant to disclose under oath what had happened. If they were dead, they would not be able to disclose under oath what had happened, which makes the witness unavailable and allows for some hearsay. In domestic violence cases, there are specific hearsay exceptions. I don't have the statute right in front of me. Mr. Marvin, do you happen to know the site for that?
I don't know the site for that. And unfortunately, I'm not prepared because the officer who took the statements while he was here yesterday could not come back today.
All right.
I believe it's something 27B, Your Honor, but I don't know the numbers.
It is 76927B, I think. But it's more expansive than that. 76927B is something different. I don't have it in front of me. Yes, there are exceptions for hearsay.
Seven 6827.
One off.
Yeah, so 76827B and C.
Does have a notice requirement, but
Yes.
in a preliminary examination, you can't do the 15 days notice. All right. Well, let's try to go as far as we can with this witness.
Okay. Jesse, are you ready?
Throw up.
All right. Did the police come?
Yes.
Did you tell them what happened?
No, not exactly. I told them that I had hurt myself doing laundry.
Your Honor,
When they came to the door, that's, you can ask.
All right. I'm going to continue this matter. You're going to have to do it as though she weren't here. You're in contempt of court for failing to answer the questions lawfully. And I'm not sure how to deal with that. We'll deal with that in a minute. You have a subpoena. You're here, you're under oath. You don't have a Fifth Amendment privilege not to testify, you can't just not answer the questions. There can be a sanction for that.
I did answer. That's when the door was open.
All right, so let's see where we can, go ahead, Mr. Marvin.
Jesse, did you, after an argument in the kitchen, did you go to the bedroom to get away and to de-escalate the situation?
I don't remember being in the kitchen, but I was in the bedroom.
All
I
right,
was laying down.
okay. How long were you in the bedroom?
15 minutes, 20.
All right.
I don't know.
And isn't it true that when interviewed, you told law enforcement that when you tried to leave the bedroom, you were pulled back by your hair, and over the course of 30 minutes, you were punched, held down, and strangled?
Like yesterday when I talked about, there was different instances where things are getting mixed up.
All right, so what I just described, did that not happen in the bedroom?
No,
Where did that happen? In the living room? Okay, all right. Jesse, did you at some point try to escape by exiting the house, the door, the front door of the home? Yes or no?
I tried to go out the door. Yeah,
And-
it was locked.
Okay. And were you pulled away from the door and brought back into the house?
Yeah,
Okay. At any point, Jesse, were you choked or strangled? Jesse, were you choked or strangled?
oh,
Okay. At any point, was your air or your breathing restricted or stopped? Your Honor, I can't continue. It's
Yes, all right.
not accurate, at least with respect to the report and what we talked about yesterday for over an hour.
Yes. Officer Greenhalgh was here, as Mr. Marvin indicated. He had a subpoena for yesterday. Through no fault of Mr. Jordan or Mr. Marvin or Mr. Bush, we weren't able to get to this case.
I do have a suggestion, Your Honor.
Yes,
If we move the case, I believe yesterday you set a prelim 2 weeks from yesterday. I would waive the 14-day notice if Mr. Marvin wants to file the 27B notice and we can proceed 2 weeks from yesterday. Just a thought.
all right. I'm going to continue this matter until Tuesday, October 10th. at 1 o'clock. There's already a bunch of stuff on there, but we'll make a priority for this. Does that work for you, Mr. Marvin?
It does. I appreciate the accommodation, and I will file my notice appropriately and properly under the statute.
Ms. Pike, I know that you're afraid and you're reluctant to be here, and this is a very common and recurring problem. I used to be the prosecutor for a long time before I was judge, and I've seen this problem many times. And even though you're not cooperating with your subpoena,
Forgot a subpoena.
all right, well, you're here, you're under oath, and you're declining to answer the questions. You did answer, I guess, eventually, although Mr. Marvin feels the answer was not truthful, which places you in a position of potentially being charged with perjury. So the question is, what do you do? Assuming that the allegations are correct and you were beaten and choked and strangled and had your eyes swollen shut, are you then further punished by the court for failing to cooperate? We've been struggling with that the entire time I've been in the system. So, Mr. Marvin, are you going to give her another subpoena for October 10th?
Yes, I am. I'll give that a shot. We'll continue to work and support her the best we can. We've got Marissa and I met with her. Officer Greenwich and I met with her. I understand the situation she's in and we care about her, and we'll try on the top.
I have a couple of questions. Are you still at the Millard Court address
Yes,
with Mr. Jordan's father?
no.
Right, I thought he
He's
was
in
with,
the nursing.
okay, so he's not there. Whose house is it?
Bart Trammell.
And you're a renter.
Yeah, he just put my name on the lease.
So your name is on the lease.
Yeah.
Very good.
No, please, yeah.
All right. Well, I was just concerned if you were going to be there alone with Mr. Jordan's father.
No.
All right. All right, we will continue this with the availability of Officer Greenhalgh, perhaps body cam videos, photographs, anything else, and try to complete the preliminary examination. Mr. Bush proposed the date. Mr. Jordan is in custody in lieu of a very high bond. He is charged with a 25-year mandatory minimum offense. It's apparent that the victim witness is reluctant to testify. So bond will stay where it is, and we're going to try this again on October 10th.
Thank you.
All right, thank you. We'll do a recess.
Thank you, Judge.
Thank you. Ms. Pike, you're free to step down once you accompany Mr. Marvin out. Sorry about all the waiting around.
I don't think so. Maybe if you could hold on to him for just for a few moments, maybe.
Mr. Jordan, I'll see you next time.
He's talking to her, and I'm just gonna sit tight.
All right. Well, that is an age-old problem. Does the victim get punished twice? I don't know the answer. I don't know what happened. I wasn't there. The affidavit is quite powerful. All right. Well, that's as much as we can do today. We'll be back again tomorrow with more